Welcome everybody who's logged on to this webinar, all 540 or so of you. We're glad to have you. Happy New Year, and welcome to the second webinar 2026, the fourth in our series. We have one during the day next week, next Thursday, the 22nd of January, from 2 to 3:30. We'll be teaching essentials of essentials for members for Planning Board and Zoning Board of Appeals staff. So that course is geared toward Planning and Zoning Board staff. And anybody else in your municipality who works with your boards and would like kind of a general training that's really geared toward them. But tonight, we're teaching Zoning Board of Appeals overview, in which we will talk about a little bit of the history of zoning and the function of zoning and what zoning is. We'll define the Zoning Board of Appeals. We'll tell you who the zoning enforcement officer is and how important that role is, and then we'll talk to you about the appellant. We all need, the Zoning Board of Appeals needs an appellant, somebody who's appealing to the ZBA for them to conduct business. And then we'll talk about the functions of the Zoning Board of Appeals in the form of interpretations, use variances, and area variances. And then we'll wrap up with, we'll discuss, we'll review procedures, which are pretty similar to those for planning boards. So if we have planning board members on tonight's webinar, they will benefit by being reminded, and they'll hear some of the distinctions between the procedures for the ZBA and their own. And then we'll wrap up with decisions and the importance of carefully worded decisions and findings potentially, and the role of your filing of those decisions and how to do that properly. So I'll just say we'll start by talking about a little bit of the history of zoning. Modern zoning is now, gosh, it feels like just a few years ago, or just yesterday almost, that we celebrated its 100th birthday. But now it's 110 years old. Modern zoning has its origins in 1916 in New York City is the earliest modern, what we call modern zoning, contemporary zoning law in the United States. And it's, but the regulation of use and aesthetics goes back to other societies. It actually has a history in the Roman Empire and even in New Amsterdam here on this side of the Atlantic Ocean. So there were forms of zoning that date back hundreds of years, and but the first modern version of zoning, and of course a lot of people don't quite understand exactly what zoning is, and we're here to help you tell them what zoning actually is. So you probably all have a good sense in your roles as local officials of what zoning is, but it really, at its very essence, it regulates land use, and that's one of the most controversial aspects of it. You'll hear people saying, you can't tell me what to do with my land, and what they're thinking about mostly is the use component. And then it also regulates the density of possible development on the land, how intensively the land is developed, and the placement of structures on a site. So dimensional requirements, use, density, dimensional requirements. Those are the three components of zoning. And if you're doing any of those, there's some municipalities that only regulate dimensional requirements and not use. And some of those municipalities say, well, we don't have zoning. But, and call it what you will, if you are regulating use or dimensional requirements, you should have a Board of Appeals. And what results from those regulations, those use and dimensional regulations, is that there are areas of your municipality that have different schedules of uses and dimensional requirements. And the result is that they become zones, and that's where the name zoning comes from. The goal, of course, is to avoid incompatible, the very basic goal is to avoid incompatible land uses, to avoid conflicts between incompatible land uses, so that they're separated. Those incompatible land uses are separated. And of course, that's the overarching goal. That's why it's the first point on this slide. But the zoning has evolved to regulate other elements such as aesthetics and character of a community. And if done properly, if you pay attention to your zoning and it's administered properly, it can be more successful. I think zoning is a lot of people love to hate zoning, and we hear a lot about the over-restrictive nature of zoning and how zoning has gotten in the way of economic development and how it's gotten in the way of the creation of housing. And it's zoning's fault that we have a housing shortage and crisis, and if only we could get rid of zoning, that those problems would go away. Well, that's a more extreme argument than was made years ago when I went to planning school, at which time we were saying, well, what we have to do is fix zoning. We have to make it work properly. So that's what we're hoping to help you do in your municipalities, in addition to serve on your zoning board of appeals and be successful with the applications you hear. So another really important point before we move on is that it's optional in New York State. It's up to your local government to have zoning or not. And we have, oh gosh, off the top of my head, and I should know this better, it's 100% of cities, all the 62 cities in the state have zoning, but maybe 80%, maybe a little more than 80% of villages do, and a little less than 80% of towns have zoning. And I mentioned a little while ago that if you have zoning, you must have a zoning board of appeals. And zoning, the legality of zoning, zoning was upheld as a valid exercise of the police power in 1926 by the United States Supreme Court in the case of Euclid, Ohio, the village of Euclid, Ohio versus Ambler Realty. And what that case essentially decided was there was a challenge that local governments don't have this authority to regulate use, and the Supreme Court said it is in the best interest of, it is a valid use of the police power, a valid exercise of the police power for local governments to regulate for the benefit of the public safety, the public health, safety, and welfare, the use of land within its borders, within their borders. And so as law has evolved both across the country and in New York State, there were early versions, early iterations of the Zoning Board of Appeals in New York. In the case of People versus Kerner, the Supreme Court of Oneida County, in the same year, I think, as Euclid versus Ambler, 1926, the court said the purpose of a Board of Appeals is to save zoning, not to destroy it, and that the property of citizens cannot and ought not be placed in a straitjacket what might be reasonable today might not be reasonable tomorrow. And this is a quote with maybe not complete, but with a little taken out, but it's a word for word extract of what the court said. So early versions of the Zoning Board of Appeals in New York are now 100 years old or older, and statute caught up, and it was codified, and now we have state statute that says what a Zoning Board of Appeals should be and some of the rules. So the Zoning Board of Appeals is something like a court. It's a quasi-judicial body which serves as a buffer for aggrieved applicants of decisions by the zoning enforcement officer and state Supreme Court. So that is where there's a court aspect to the work of the Zoning Board of Appeals, and that's why we say it's quasi-judicial. So we wouldn't be anywhere without the zoning enforcement official, who is the person at the local level who enforces the zoning regulations. And that person is often also the person who enforces the Uniform Fire Prevention and Building Code, but sometimes it's somebody separate, and the designation is needed to give that person to say, this person is going to this local official who also enforces the Uniform Code, as the case may be, will also serve as our zoning enforcement officer. And that's a lot to keep track of. That's a lot for one person to do, especially in smaller municipalities where the enforcement official might only work a few hours for smaller and more rural municipalities, so towns and villages in particular. But that person, the zoning and the code are separate, and the code is a state law that local governments often choose to enforce, and zoning is a local law that local law or ordinance, mostly law, that that local governments are charged to enforce, that they enforce themselves. So I mentioned the codification of the Zoning Board of Appeals and statute. There it is in town law, village law, and general city law. It's the Zoning Board of Appeals statute is, I believe, totally identical in each section of law. There's some sections of general city law and village law that are slightly different from town law, but when it applies to Zoning Board of Appeals, they're nearly, I think they're the same. They're all the same. So there are three sections, and we often refer to town law because there's the greatest number of towns in New York State. There are 933 towns, 500, I think 32 villages, 62 cities. So we go with town law, and you can find these laws in online. There are a couple. You can just search for New York State statute or town law 267, town law section 267 if you want to do that, and you'll be able to pull that up online. But in our guide to planning and zoning laws of New York State, which is on our website, you can also search for that. These statutes and other sections of statute are collected in the guide. Those statutes that apply to land use planning and regulation in New York are compiled in the Guide to Planning and Zoning Laws of New York State. So I am going to pass control of the screen on to Lindsay, and she'll continue.
Thanks, Chris. Okay, so zoning board members are public officers. The appointing authority for zoning board members is the city mayor, the town board, or the village mayor with the approval of the trustees. Zoning boards can consist of 3 or 5 members. There are some boards still out there with 7 members, but that is becoming less common. The terms of office of each member corresponds to the number of regular members' seats on the board. The terms are staggered to prevent complete turnover and provide continuity of institutional knowledge, consistency of decisions, and insulation from the changes in political administration. For the oath of office, pursuant to Public Officers Law, each member must take and file an oath of office with the municipal clerk within 30 days of the commencement of each term of office. If not filed, the position is considered vacant. However, failure to file does not invalidate decisions made while a member was serving without oath taken and filed. If you fail to file, then you must be reappointed and then file your oath. You can also be considered a holdover. If no one tells you the term is over and you continue to serve, you remain a member, but the appointing authority can appoint someone else at any time. Qualifications for membership. As a public officer, to serve on the Zoning Board of Appeals, you must be at least 18 years of age, a citizen of the United States, and a resident of the municipality in which the board has jurisdiction. When you live in a village, you are both a village and town resident, but the reverse does not apply. You must live in the village boundary to serve on that board. No person who is a current member of a legislative body can be eligible for membership on the Zoning Board of Appeals in that municipality. State law requires members of ZBAs, planning boards, and county planning boards to receive at least 4 hours of training per year, like we're doing right now. If a board member does not meet that required training hour, it does not void their decision, but it can prevent them from being reappointed. You can bank extra hours and roll them over year to year if you have more than 4 hours in 1 year. Training may be provided in different formats: in person, webinars like this, online interactive courses, which can also be found on our webpage. Your municipality decides what qualifies as training and tracks your training hours. To ensure that training qualifies, the best practice is for the town board to pass a resolution to accept a list of approved classes. For example, the resolution could have language saying any training by New York State Department of State or sponsored by the County Planning Department counts towards your annual training. A municipality can waive requirements for good and sufficient cause if it's in the best interest of the municipality to do so. Municipalities can be stricter by requiring more training credits than the state or removing members who fail to meet the requirements at the end of the year rather than wait until the end of the term. For a board to conduct business, they must achieve a quorum. This is the majority of a fully constituted board, including absences and vacancies. So if you have a 5-member board, that would mean 3 members must be present. This is why alternates can be helpful, because it prevents the holdup of applications if a board member is absent or must recuse themselves. New York State statute only allows alternates to serve when a board member must recuse themselves for a conflict of interest. But a municipality can pass a law superseding that for an alternate to serve in the event of an absence. The governing board determines the terms of office, such as a number of alternates, length of term, and adopts that by local law or ordinance. Alternates are appointed in the same way as regular members, and it's up to local law whether alternates continue to replace an absent member once they return or if the alternate takes turns. In most cases, if you as a board member have familiarized yourself with the record of an application, you can vote on an issue even if you missed the meetings. The chairperson is chosen by the appointing authority, which may be the town board in a town, in a village usually appointed by a mayor with approval of trustees. If not specified in local law, the ZBA selects the chairperson. The chairperson is a regular member and has no extra rights or powers. The chair's main role is presiding at meetings and hearings. The chair can change at any time by appointing authority, and there's no designated term. It is a good idea to have a vice chairperson in case the chairperson is absent. The chairperson may prepare the agenda, they might serve as the liaison with the governing board, sign official documents, and supervise the filing of documents. These are important tasks to ensure that your board is functioning properly and not making you vulnerable for public challenges for missing procedural deadlines. Conduct and ethics are important to be aware of as board members. While cause is not defined in the law and is subject to much interpretation, the legislative body may determine locally the reasons for which a board member may be removed. These standards should be adopted by the legislative body within its code of ethics. Have good and clear bylaws for board members regarding adequate attendance, appropriate and ethical behavior, and continued training for reasons for removal. In terms of board membership, attendance is not defined in statute, but it may be written into local law. If a member is unwilling to get training, usually not cause for immediate dismissal, but they will not be appointed for another term. The local governing board must hold a public hearing before dismissing a member of the zoning board. All ZBAs have appellate jurisdiction, and that means that they have the authority to hear and decide on appeals of decisions made by the zoning enforcement officer. In other words, applications come to the ZBA on appeal. In some municipalities, ZBAs also have original jurisdiction because the local governing board has delegated specific review power to them to review special use permits, or even more rarely, site plan review. This is known as original jurisdiction because the application originates with the ZBA and not with the ZEO. As a reminder, the state statute specifies that planning boards handle subdivision. And I'm going to pass it back over to Chris.
Thanks, Lindsay. To get to the Zoning Board of Appeals, the zoning enforcement officer must have acted on the zoning regulations by granting a permit, or it's more common, denying a permit, or in some cases issuing a citation for a violation or some other enforcement action. So the zoning enforcement officer almost always has to have acted. Something has to have happened before the applicant goes to the Zoning Board of Appeals, before the appellant, as we call the applicant for the ZBA, goes to the Zoning Board of Appeals. The exception is when there's a direct appeal for an area variance with a review of subdivision, site plan, or special use permit. And one of these days I have to replace this photo because it's fuzzy and it's been around for a long time, and I swear I've gotten a good photo similar to this where we can talk about the direct appeal. But the relief that we're talking about here is from the minimum frontage on a curved street. So frontage is there's usually a minimum frontage for lots to be created, and sometimes on a curve there will be a little less frontage, and that doesn't mean that the lot can't be developed, but it might involve a direct appeal. And some people this is a relatively simple concept that confuses some people. So we'll try to explain it as simply as possible. So the ideal way, what's happening here is this is the exception of the enforcement official not issuing a denial for the appeal for the area variance to go in front of the ZBA. So here's how it should happen. The planning board gets the subdivision plat and has a preliminary review of the subdivision, and might see, and maybe it was the enforcement official who identified that, or it could have been members of the planning board, identified that there was a deficiency in the lot frontage, that a couple of the lots didn't meet the minimum lot frontage, and it could be a site plan review with that needs some relief from the side setback. It could be a commercial building that's being constructed, and we'll give you some more examples later on, but this is one for subdivision. So the planning board would make a recommendation to the Zoning Board of Appeals and send the plat to, and for subdivisions, the Zoning Board of Appeals shall request written recommendation from the Planning Board. That's the second bullet there. If the Planning Board doesn't make a recommendation, the ZBA just goes ahead and considers it. But the Planning Board should make a recommendation for all relief that's part of a review that the Planning Board is conducting, site plan, special use permit as the case may be, or in this example, subdivision. And the step that's being skipped is that the enforcement official isn't denying anything. It's skipping the benefit of the direct appeal is the efficiency of just going directly to the ZBA rather than to the enforcement officials to say, no, you can't do this. It's being reviewed by the preliminarily by the Planning Board, which makes a recommendation to the Zoning Board of Appeals. The Zoning Board of Appeals can follow exactly what the Planning Board says or not, deny the relief or grant less or grant a little more. But then it goes back to the Planning Board in best practice. So this is really, it's really it's under control of the Planning Board primarily, but then it goes to the ZBA. The ZBA, there's some reliance on the ZBA to grant the relief, and if the ZBA doesn't grant all the relief that's needed, then the Planning Board has to get creative and act accordingly, maybe the applicant too, and there might be some conditions in there. But that's what the direct appeal is. It's avoiding the denial by the enforcement official. But best practice is still to go to the Planning Board, then to the ZBA, then back to the Planning Board in cases in which the some relief is needed as part of a site plan review, subdivision, or special use permit application. So who is the appellant? Somebody who has standing, and that is usually the person denied the permit or cited for the violation. Sometimes it's a third party, a neighbor, or an organization with an interest who stands to be harmed by the enforcement official's decision. And occasionally, and this is right in statute, it's a municipal office or department, board, or bureau. The quotes are directly from statute, so that could be another board of the municipality or possibly an office or a department. And we don't see those too often. Most of the time, it's the person who is denied the permit, occasionally a third party, a neighbor. And when does the appeal get filed? Within 60 days of the enforcement officials filing the action. The exception is when there's a third party, a neighbor, for example, it's 60 days from the date that person should have known or could have knowledge of the enforcement official's action. So, and then the notice is, it's usually an application form that gets filed with the Zoning Board of Appeals. It goes to the building office and then eventually to the ZBA. And those happen differently in every municipality. But this example here is to illustrate that an appeal stays enforcement proceedings. So it's kind of a funny thing when you file an appeal, there's a stay of enforcement unless there's a declaration of an emergency situation if there is a threat to life or safety. So a garage too close to the property line probably wouldn't qualify if there were hazardous waste being stored here, or something, some urgent matter in which a court injunction were needed to override the stay. That would there's a stay of enforcement proceedings, and what that means is, remember the example on the last slide about 60 days from when a third party could have known. So let's say I live in the brick house and I get a permit in January to build this garage. Lindsay lives in the wood frame house, the clapboard house on the left, and I get the permit in January, but there's no way for Lindsay to know that I'm about to build a garage right on the property line until I pour the slab in, let's say, April or May. That's when she could know. So then she has 60 days from that time to file the appeal. But if she's away for a long time and she misses that window, then she's out of luck. But let's say I get the permit and there'd be no public hearing here, so nobody could, there's no posting of, it's just a building permit for a garage. But let's say Lindsay comes home one day and sees that there's this garage right on her property line, and she knows that accessory buildings in this zone need to be 4 feet off the property line, let's say, and this is not 4 feet off the property line. So she calls the building office and says, get over to my house. I think my neighbor is building this garage illegally, and the enforcement official comes and slaps a stop work order on me to build the garage. And I say, well, you know what, maybe it is closer to the property line. I'm going to file an appeal, or let's say I disagree. I say, no, it's 4 feet off the property line. I'm going to appeal for an interpretation. We're going to talk about that in just a minute. Or I'm just going to appeal for an area variance if the board decides not in my favor. So that stays in enforcement in proceedings. So once I appeal for that interpretation or area variance, there's a stay of enforcement, and I can continue building that garage, but it's at my own risks because I'm not guaranteed to be given that area variance. And I know we get a lot of calls about people, more people than ever, asking for forgiveness rather than permission, and we don't have. There's not a legal or technical answer to that. That's just common sense. There are boards all over the place where people are building without a permit, and of course there are famous cases that we talk about in our area variance, a deeper dive course, and other cases in which things haven't gone the way the property owner predicted them to, and the property owner had to fill in the swimming pool or dismantle the building, as the case was. So this is kind of a quirky element, the stay of enforcement, and it's a more difficult concept than many in this course. So if anybody has questions about that, you can email us or call us during regular business hours. So we're going to move on to interpretations, and Lindsay's going to handle those. So Lindsay, it's your turn.
Okay, thanks, Chris, and thanks for teeing us up for interpretations. So in its appellate capacity, the ZBA can grant or deny two types of relief, interpretations and variances. In either case, the ZBA will either affirm, reverse, or modify the enforcement officer's decision. If the appeal is for an interpretation, the ZBA's decision will be based on the municipal zoning regulations. If the applicant believes the ZEO's decision is incorrect, the appropriate request is for an interpretation reversing the officer's decision. It is also possible for an applicant to make a request for an interpretation in the same application ask for a variance if an interpretation in the applicant's favor is not granted. Or similar use is a term we recommend removing from your local zoning because it is unclear, a cause for confusion, and a source of appeals for interpretation. In this type of appeal, the appellant is saying that they believe the ZEO misinterpreted the local zoning code or has wrongly applied the law. Often the ZEO has denied someone's application for a building permit. It could be a disagreement over certain required distances or other dimensional requirements or the method of measurement, such as where to measure from or the center of the right-of-way, height, or height on a slope. Also remember that definitions are really key to this, and look in the dictionary to further distinguish differences. This is why clear definitions are so important. Often conflicts begin when there is a new ZEO or zoning language is vague and subject to debate. The governing body can help to avoid such disputes by using plain language and including many clear and well-drafted definitions in the zoning code. And we're going to go over some examples of that as well in a couple more slides. So basis for interpretation decisions. If requesting a reversal for an interpretation, the applicant must prove that the enforcement officer's decision was incorrect, or according to the municipality's zoning regulations. If the ZBA has heard a case in the past which involved an interpretation of the same provision, the ZBA's decision should be consistent with its prior ruling. If the ZBA has never interpreted the particular provision at issue, it will use its best judgment as the municipal governing board's original intent in enacting the provision. The ZBA will try to arrive at the best practical solution for future application by the enforcement officer. Careful and thorough reference will be given to all definitions and other provisions of the regulations. If necessary, the ZBA will refer to authoritative publications on planning and zoning law. The applicant may, of course, use those resources in presenting their own case as well. It's very important to have good records and preserve institutional knowledge. Keep a database of records of past decisions. This will save time and eliminate searching through years of records. They should be stored chronologically by date and also cross-reference the location of the property. Interpreting zoning is about evaluating the current situation with existing zoning regulations and past practice. Look at past decisions, look at when zoning was enacted, look at meeting minutes, hearing comments to find the intention of the zoning component in question, and you can use all of that information to make your decision. All right, so here's an example on the importance of clear and defined definitions. So in the matter of Washington Avenue Armory versus the City of Albany in 2014, the Armory, which is situated in a commercial office zoning district, held rave events, and that prompted multiple cease and desist orders alleging that the events were not among the permitted uses. The petitioner did not challenge these orders, but submitted an application to the zoning board for an interpretation for what events are permitted as an auditorium, which was an allowed use, but was not defined. The zoning board found that the use of the facility as a party, nightclub, dance club, or other similar event is excluded from the definition of an auditorium because the board relied on a dictionary definition of an auditorium as the area of a theater where the audience sits. Based on those definitions, the zoning board found that the applicant's use of the Armory for a rave, party, nightclub, or similar events did not provide the fixed seating and therefore could not be allowed. On appeal, the court found that the board ignored alternative definitions for auditorium, including a large room or building where people gather to watch a performance, which makes no reference to an audience sitting. The court found that the decision based solely on its limited interpretation of the definition of auditorium, requiring fixed seating to the exclusion of the other commonly accepted definitions, was unreasonable and annulled the board's decision. So this case highlights the need for clear definitions. By having clear definitions, you prevent future conflicts and challenges like this to your zoning. All right, and another example. So Cupid's Video Boutique versus the ZBA of the Town of Babylon. This case is from 1994. The Town of Babylon Code restricted adult uses within 500 feet radius of any residential zone. In this case, the ZBA denied an adult use permit requested as of right on the ground that it was within a 500-foot radius of a residential area. Applicant claimed that the 500-foot measurement from the property line rather than from the front door was arbitrary and capricious. Measuring from the building entrance would meet the 500-foot minimum. The ZBA ruled the measurement is to be taken from the property line, and the court agreed. Unlike those cases involving section of the Alcohol Beverage Control Law relied on by the petitioner and the trial court, there is no express statutory language requiring that measurements be taken in a straight line from the center of the nearest entrance. The method of measurement is to be evaluated according to the general principles governing the interpretation of zoning ordinance by local boards. The interpretation of a zoning ordinance by a local board is entitled to deference, so as long as it is not irrational, unreasonable, or inconsistent with the governing statute. The clear purpose of this ordinance at issue in the case was to eliminate secondary effects of adult uses, as well as to attempt to control the future development in business districts and not to regulate expression. The board's measurement of the 500-foot radius in this case was not irrational, unreasonable, or inconsistent with the purpose of the ordinance. The record supports the conclusion that the secondary effects, which the ordinance was designed to minimize, are in this case incident to the entire parcel. And now I'm going to pass it back to Chris to talk about use variances.
Thank you, Lindsay. Use variances are, by design, very difficult to attain. The four-part use variance test, and of course, a use variance is a request to use land for a purpose not permitted by zoning. In the interpretation, the appellant disagrees with the interpretation of the enforcement official. When the appellant is applying for a use variance, the property owner or business owner or person who wants to use the property in a certain way acknowledges that they're on the same page. This is a use that's not permitted by zoning, but there's an argument that's about to be made. And of course, the alternative to a use variance is to rezone the property. There is the feeling among a lot of people, we get lots of calls from local governing board members, members of zoning boards of appeals who say, well, if you were to rezone the property, it would be spot zoning, wouldn't it? Well, it's a lot more difficult to prove spot zoning than it is to prove that the use variance was illegal, because this four-part test is purposefully so difficult. Because if you're violating, as a zoning board of appeals, this four-part test, you are legislating. You're essentially legislating. If somebody can prove that the applicant property did not satisfy all four of these factors, the zoning board of appeals was essentially changing the zoning as an unelected board. The local governing board is elected, and the local governing board can make a case for changing the zoning for a certain use, and arguably, and this is a good thing, changing the zoning back if it doesn't work, if it's problematic. So the burden of proof is on the applicant. The zoning board of appeals has the upper hand to say no, because this four-factor test is so difficult. And the first factor is that the applicant must make the case that the land is not capable of making a reasonable return with any permitted use, any current legal non-conforming use on the property. We'll talk about that in a few minutes. And any use that might be allowed by a previous use variance, might have been permitted by a previous use variance. Those are relatively rare, and the ZBA must consider the entire parcel, not just the small portion that might be subject to the application, that the owner might want to use in a way that's different from zoning. So the no reasonable return argument is a really difficult one. The applicant must make the case that this property, not me, because I paid too much for it, but the property, it can't be capable of making a reasonable rate of return. And people say, well, what's the formula for that? Is there a formula? Can you recommend the formula? No. That's why we have multiple members of a ZBA. It's you, and you don't have to agree with the applicant's numbers, the attorney that puts forward numbers or their accountant. You could say that's a reasonable rate of return and then make the argument in your decision document of why it's a reasonable return. You have the upper hand to say no, you don't have to agree with the expert's opinion. The case we point to here involved a neighborhood with single-family homes in which the owner, there was a vacant lot, and the owner just wanted to build a two-family home because it was more profitable. Renting out both units would be more profitable than renting out a single-family residence. And the Zoning Board of Appeals denied it. The owner challenged the denial, and the court said, and this is a frequently quoted line, it's a line that appears in many cases, the property owner is entitled to a reasonable but not necessarily the most profitable return. So the reasonable rate of return is the first factor. The unique circumstances is the second. The appellant must make the case that the parcel is the only or one of very few affected by the zoning to create that hardship. And remember, it's the uniqueness of the site, the land, not the uniqueness of the plight of the owner. So if the owner paid too much for the property and then needs to change the use because it's more lucrative, that's not a compelling case. So in the photo, it's a neighborhood school that ceased to function as a school, maybe in a single or two-family residential neighborhood, and that's one of those uses that could be a unique circumstance in that kind of neighborhood. But the hardship can't be self-created. So the owner can't purchase the property and then say, oh, I have under the current zoning. The new owner can't purchase the school if it's zoned single-family residential or two-family residential and say, oh, now I have a hardship because I just bought this school in a single-family residential zone. But the owner of the property, the contract vendee, or the owner of the property or the contract vendee can appeal for the use variance before the person who's interested in buying the property, contingent on receiving the use variance, can say, I'll buy the property if we get this use variance. But the zoning has to have been on the property before the zoning has to change under the ownership of the person who appeals for the use variance or the person who is interested in purchasing it. And then the fourth one is neighborhood character. And of course, when I was a municipal planner, people would come into the office and say, I need a use variance, and what I'm going to do here is going to be great for the neighborhood. That was always the argument. It's not going to affect the neighborhood in a bad way, in a negative way. It's going to be great for the neighborhood. They don't start with, I can't make a reasonable return on this property. They say, what I'm going to do is going to be really beneficial. So in this example, we've always imagined that it was the laundromat next door that affected the neighborhood character in a negative way. But imagine the possibility, and I'm going to suggest this, that the laundromat came in next to this Victorian, this really charming Victorian house before there was zoning. And then there was zoning on the house, and let's say that's a big single-family residence, let's say, and maybe the owner said, you know, zoning is in now, and I can't get this property rezoned for commercial use because it really, this building defines the character, but we have to it's not viable as a single-family residence, and we need a use variance to use it as we're going to make it multi-units, and we're going to put a law office on the first floor, and I think, in fact, that's what's there. So the Zoning Board of Appeals was able to attach conditions to be sure that this Victorian house, even though it's a multi-unit residence now with a law office on the first floor, maintained its character for the houses down the street, so that so that the commercial character of this corner didn't continue down the street. But you asked that question for neighborhood character: is the proposed use fairly consistent with the existing development? And I'll use an example that came to us recently involving a school. I think it was a school that had closed that was associated with a church, and it was not viable anymore. The church had owned the school building since before there was zoning, and when the member of the Zoning Board of Appeals called, I said, did you consider rezoning the property? That had been considered, but the town board said no, we don't want to rezone the property for the proposed use was multi-unit apartments in this former school building, which is a good reuse of a school, and there's a need for housing. A lot of the time former schools are reused for affordable sometimes, and sometimes senior housing, and there's definitely a need for all of that. And it's a good adaptive reuse for former schools, especially older buildings, which have the ceiling space for new systems and mechanicals. And the town board denied the rezoning petition, and the Zoning Board of Appeals, it met all the criteria. But there are not many examples out there that do that. The rezoning the property is almost always a better idea than issuing a use variance. And sometimes there's resistance because people think, okay, it'll be faster if we go to the Zoning Board of Appeals, and we don't want to be charged with spot zoning. But if you don't satisfy that four-part test, that's a lot easier. That's a much easier argument for somebody who didn't like the decision to make in court and for it to be invalidated. So I mentioned a little earlier pre-existing legal non-conforming uses. Those are uses that existed prior to current zoning. They have to have the benefit of pre-existing legal non-conforming uses. The use has to be legal at the time it existed. Sometimes we have those uses that weren't legal then, and sometimes the owners claim they want those advantages, but then it's found that they were never legal. But the bar in the residential neighborhood, for example, the billboard in a town that doesn't allow billboards anymore, a use variance is not necessarily needed for that use to continue to exist, but if that use wants to expand, a use variance is needed to expand unless there's some provision for expansion worked into the zoning. And those pre-existing legal non-conforming uses are not necessarily permanent. Many zoning laws have an abandonment provision that say once this use, operation of either the business or posting of the billboard ceases, the use will for a year. If it's abandoned for a year, then it loses its non-conforming status, and whatever goes in next has to conform with the zoning. That's pretty common. Less common are amortization clauses. Amortization is used a little more with billboards and other signs. When the zoning changes, the signs often have to, and this, it could apply to other uses, but it's pretty controversial. And the idea of amortization is that you allow the the user of the pre-existing legal non-conforming use to recuperate the investment. That investment is usually less with signs than it is with other uses, but that the use can be amortized out after a certain number of years and then has to comply. It's like a grace period, has to comply with the zoning after that point. So Lindsay's going to talk about area variances.
Great. Thanks, Chris. All right, so area variances. So area variances provide relief from the dimensional requirements of zoning rather than the use. This driveway probably received an area variance in the form of a relief from the setback of the neighboring property line. That stockade fence might have been a condition of that variance being granted, and zoning restrictions from which area variances are often requested include lot size, setback requirements, height restrictions, lot coverage maximums, and frontage requirements. The ZBA must evaluate whether to grant the area variance based on a 5-part balancing test. The balance between the benefit to the applicant and the burden on the community if the variance were granted. Area variances can be used to make a project better by finding that balance between the community and the applicant. The area variance test is much less stringent than the use variance, and the appellant need not pass them all. We will cover each of these factors listed on the slide in the upcoming slides. So first, will the granting of the variance result in an undesirable change to the character of the neighborhood, or will it be detrimental to nearby properties? Are there conditions of approval that make it a better fit in the neighborhood and lessen the impact? Examples of this that are not particularly burdensome are screening, including landscaping and also incorporating that it must be maintained, lighting, colors, and the building materials. The conditions must be reasonable and directly related to the land. In the first photo, that height of that tower, as you can see, is not consistent with the rest of the block, and this could have been mitigated by reducing the height or a deeper setback. In the second photo, the signage size or height variance could be approved with conditions that the sign be kept in with the architectural character. So this sign is located in Lake Placid, New York, and as you can see, it kind of has that wooden motif on it, as well as the gooseneck lighting instead of being a backlit bright sign. In the third photo, the used car lot isn't great for pedestrians' environment. This could be improved by requiring some landscaping or buffer to screen the parking lot from that sidewalk. Okay, are there alternatives not requiring a variance? The applicant should explain why alternatives that would not require an area variance do not meet the applicant's needs. One of the benefits of the area variance process is that the board can provide input on design and provide conditions that support the community character and the applicant. Typical examples of projects requiring area variances such as garage, additions, driveways, they may not be possible to follow your current zoning based off of additional existing factors. One example is an applicant that wanted to add a mudroom to the back of their house, but it would exceed the rear setback requirement, where it could fit on the side of the house, but then they would enter through their dining room and it wouldn't fit the character of the neighborhood in terms of the design of the house. The board allowed them to build it on the rear because it also benefited the community character by having it more hidden and not being an eyesore on the side of the house. So it was a win-win situation for both the applicant and for the community. The board's job is to ask questions and see if there are solutions the applicant has not thought of, and the goal is to make sufficient showing that the applicant met test requirements. Seek to balance the interests of the property owner and the community. And site visits can really help to understand the circumstances and possible alternatives that can provide that balance between the applicant and the community. Consider alternatives for function, design, cost, and aesthetic reasons. So substantiality of the request. So the goal is to approve the minimum variance necessary. Substantial is a subjective term and can change with the board's perspective. There's no official method to this, but you should look at the facts of each case that comes in front of you. How much of variance is requested? What is that degree of substantiality? So are they asking for a 10% variance or a 50%? Is it going to cause any change in the accessibility of the lot? A site visit can be helpful to understand the circumstances and possible alternatives. Also, you should consider the magnitude, not just the measurement. You know, if it's 2 feet out of 30 feet, that's only 7% versus 5 feet out of 10 feet, that's a 50% variance, so that's a much more substantial ask. If the setback is 5 feet and someone wants to build right on the property line, that's 100% variance, so that's very substantial. Remember, the goal is to grant the minimum variance necessary. All right, physical or environmental impacts. Consider the physical or environmental impacts and identify possible mitigation methods. If there are drainage issues, then a bioretention pond can help absorb stormwater. A variance for total lot coverage or imperviousness related to a parking lot could be needed. To address this, the board could reduce the required parking to avoid the impacts of that added imperviousness. And remember that the environment is a broad term and can also be traffic impacts or narrow street frontage of a flagged lot. So is the situation self-created? Most area variances are self-created. For example, a person builds a shed in the setback and comes in for a variance after the fact. If it is self-created, according to statute, it can't alone be the reason for denial. It is just one more factor to consider when reviewing the application. Conditions. So the ZBA has statutory authorization to establish conditions. Conditions must have a nexus with the land. Conditions are meant to mitigate the impacts of the project on both the neighborhood and on the integrity of the zoning law. For example, do not condition the granting of a variance on issues related to a separate property the applicant may own. Another example can ask for a higher fence, such as adding the lattice to the fence on the slide, but it can't ask the property owner to reconstruct the municipal sidewalk on the other side of the fence. Do ask that screening, fencing, or vegetative be maintained. Do not condition any aspect of internal business operations that are not directly related to the impact of the use on its surroundings. Conditions should be reasonable, not overly onerous or burdensome for the owner. Variances and interpretations are granted on the land, not the owner. There are temporary variances, but they are rare. For an example, a construction trailer. And the Donovan case reference on the slide, the Town of Colony ZBA tried to restrict the variance to the current business owners, which is a real estate business conducted out of a former residence. When another business owner purchased the property with plans to continue in real estate, they were told the use variance no longer applied, as it was granted on the condition of it only applying to the previous owner. The court found in favor of the petitioner that variances apply to the land and not to the individual property owner. And as I mentioned earlier, you need to grant the minimum variance necessary. Whether the ZBA decides to grant a use or area variance, state law requires the ZBA to grant the minimum variance necessary to provide relief, while at the same time taking care to protect the character of the neighborhood and the health, safety, and welfare of the community. For these same reasons, the ZBA may also impose reasonable conditions on the granting of any variance. The ZBA has broad authority to scale back what is asked for and grant a variance for less of a setback, a lower height, or fewer housing units than requested. This is in statute in the sections referenced on this slide. And now I'm going to turn it back over to Chris to talk about procedures.
Thanks, Lindsay. And remember, those planning board members who are on, these are largely the same as yours. This is a refresher for you. And of course, we do highly encourage planning board members to take ZBA overview, and vice versa, ZBA members to take planning board overview, because then you have a context and you can understand the entire land use review process and your role in it. So rules of procedure, to be binding, we say that rules of procedure must be adopted by the local governing board, and rules of procedure go a step further than your zoning regulations. They cover the logistical details of your board and rules that you might want to have, kind of internal rules for duties and how to take minutes and get the minutes out there, and what has to be signed and how referrals, the overall process and the nuts and bolts of it. And if you would like examples of rules of procedures, we can share some with you. We can share samples with you if you're interested and you don't have those of your own. They are particularly helpful when there might be a longtime chair who's absent, relatively new board members, or turnover of the board, where there are a lot of new members who might not be certain of the way things are done. Rules of procedure can come in pretty handy there, and they're more specific and precise than something like Robert's Rules of Order. The State Environmental Quality Review Act, SEQR, the Zoning Board of Appeals is often an involved agency where an application goes first to the planning board and might need some dimensional relief. And the planning board is lead agency. The ZBA is an involved agency and weighs in and participates in the process, or does its own EAF, environmental assessment form, short EAF, if the activity is unlisted or type 1. But many of the activities by the Zoning Board of Appeals, if it's just a area variance for setback relief or interpretations, for example, those are type 2 actions, which end the SEQR process. The Zoning Board of Appeals can classify them as type 2 in nature, and there's no need to go further in the SEQR process in those events. And many of the applications, the appeals that come before the ZBA are type 2 in nature. Meetings of the Zoning Board of Appeals are subject to open meetings law. It's an official body, and to comply with open meetings law, you must post the notice to the media in a conspicuous place, a physical location. The more, the better. Maybe the library, the municipal building, and on your municipal website. If it's scheduled, if your meeting is scheduled more than 1 week in advance, that notice has to be at least 74 hours ahead of time. And if it's a special meeting that was scheduled less than a week in advance, then the notice should be posted as early as practicable. And the theme of open meetings law is openness and access, and for the public to be notice and access, for the public to view the work of its government. And I'll just say very briefly about executive sessions. There are very few reasons the Zoning Board of Appeals should stop its open meeting and go into executive session. And those reasons are listed in our publication, Conducting Public Meetings and Public Hearings, and in open meetings law itself. you're not triggering open meetings law if 2 members are speaking, or if you're seeking the attorney-client privilege covers meetings with the board and your attorney if you need to meet with your attorney with questions. But other than that, if you're visiting a site and the property owner and the municipality do not want the public, do not want it to be an open meeting, then the suggestion that many have for the board is to visit the site in a group smaller than a quorum, so it wouldn't trigger open meetings law, or if you're going as a quorum, to observe and not discuss, certainly not deliberate about the merits of the application, because that is a violation of the spirit of open meetings law, that deliberation should be in public. So if there's a case, the town of Riverkeeper versus the town of Somers, in which the board did visit the site as a quorum, but was clear in not deliberating and just gathering information. But an easy way to avoid that, having to prove that charge, is to visit the site in a group smaller than a quorum and to report back at the open meeting on what was observed. So another recent change to open meetings law includes this, that records scheduled for discussion at an open meeting must be available to the public at least 24 hours prior to the meeting, and this usually involves posting on the municipality's website. If it's not feasible to do this, then having copies of the agenda and the applications for the public to access at the meeting itself is the next best thing. There's an important distinction between meetings and hearings. At public meetings, it's the board doing its business, and the public isn't necessarily entitled to speak at those gatherings. But most boards do give the public some opportunity to speak, whereas public hearings are for the purpose of hearing from the public. And the hearing notice requirements, every application before the Zoning Board of Appeals requires a public hearing by statute. And so to do that, the state hearing notice requirements are the same. They include the same requirements as having an open meeting. And in addition to that, there's the requirement to have a legal notice in the official newspaper at least 5 days prior to the hearing date. And that's the official newspaper, one that has a subscription, not online, or not, it's not just posting it on Facebook or other social media, although you can certainly do that, but the legal requirement is notice in the official newspaper, and not just the Penny Saver. And again, if you want to put it in the Penny Saver or My Shopper, you can do that as well. The whole idea of open meetings is to notify as many people as possible, is to get the word out about the open meeting. But that's a legal requirement. We've had a lot of questions in recent years about the unfortunate demise of many local newspapers, but this is still a requirement. So if you want to talk to us about that, you can call us during regular business hours. And then sometimes there's the requirement to mail the notice of the appeal in certain cases, as you can see on the screen. And then certainly we'll talk about General Municipal Law 239M and 239NN shortly, those triggers, but it's not a statutory requirement to mail notices to neighbors within 500 feet, for example, of the subject property. The property that is subject to the area variance or use variance for which there might be a public hearing. That's something that local governments add, and if it's a requirement at the local level, you have to follow it. There are other additional local noticing requirements. A sign posted on the property is often considered best practice because anybody who is living close by, maybe a renter, who wouldn't receive the mailing to the neighbor because the mailing would go to the owner of the property, not necessarily the tenant. And of course, as I mentioned earlier, you could use a listserv or social media to notice the hearing, or as we said, the flyers, advertising flyers, in addition to the official paper. And then we just say here, and I used this in my example earlier with the garage, if you're doing a hearing notice, let's say for an interpretation, there's the possibility, or the owner sees the possibility, or the ZBA takes that step, that there is the possibility that the Board of Appeals, the Zoning Board of Appeals, will not vote in favor of the applicant's interpretation, but side with the enforcement official. The owner can then continue on and appeal for an area variance, and I used that example with the garage. And so you can include language for both in one hearing notice. That's what this slide is really saying here. So I think Lindy's going to talk about the required referrals, 239NN and then 239M.
Yes, thank you, Chris. So there may be instances where you need to notice the adjacent municipality under General Municipal Law 239NN, or as we like to call the Nice Neighbor Law. And this encourages municipalities to communicate with one another about applications that could have an impact beyond the municipal borders. So General Municipal Law Section 239NN requires that notice of special use permit applications and applications for use variances within 500 feet of a municipal boundary be sent by regular mail or electronic mail to the clerk of the adjacent municipality at least 10 days before the public hearing. And the municipal clerk can share it with the members of the local governing board and other local officials. Representatives of the adjacent municipality can come to public hearings and speak and provide comment. So there is also, as you're probably familiar with, county referral. So under 239M, and M we like to say stands for mandatory, applications need to be sent to the county if they are 500 feet from a municipal boundary, a state or county park, highway, stream, or building. Area variances within 500 feet of a farm operation in a state ag district are exempt from referral requirement. We encourage municipalities to maintain and refer to the map like you see here on the slide. What is highlighted in green means it's triggered that county referral and it's easy to reference and ensures that this procedural step isn't missed. Failing to refer could be deemed a procedural defect if challenged in court, and the entire action may be overturned. County planning agencies may enter into a referral agreement with the referring bodies to exempt certain actions from mandatory referral, or this could be done through your county charter. So you cannot take action until one of these two actions occur. The ZBA receives the county planning agency report, or 30 days expires since the date the county planning agency received a full statement of the referral. You cannot condition an approval pending the county returning a favorable or neutral recommendation. No early votes. It can be extended with the county by mutual consent, but this should be in writing. There is also the 2-day rule. If the referring body receives the county planning agency's recommendation after the 30 days has passed, but 2 days before the local board makes its final decision, the local board must consider the county's recommendation as if it had received it within the 30-day window. So that's a little caveat. We like to have those in our laws, make it more complicated, but the effect of county referral. If the county recommends disapproval or modification within the time allowed, then it requires a supermajority or a majority plus 1 vote for the referring body to approve the application without the recommended modifications. So if you have a 5-member board, that would be 4 votes. And you must send a notice of final action within 30 days of the local decision to the county. If the local board acted contrary to the county recommendation, it must include the reason why in that report. All right, so taking action. There is a distinction between appellate and original jurisdiction actions. An applicant needs a majority affirmative votes of the fully constituted board, and the chairman counts in voting just like everyone else. So for example, if you have a 5-member board, 1 vacancy, and 1 absentee, so 3 board members are present, you've achieved a quorum, and then 1 votes yes and 2 vote no. For an appeal, variance, or interpretation, that would be a default denial if there is not a majority approval. If there is not a majority for approval after 62 days. This is to prevent a no action stalemate. It is recommended, if this happens, that a motion to deny is made so the case isn't open for scrutiny and the applicant knows where they stand. However, if a motion fails on an appeal or interpretation, the board may take additional votes and amend the motion within the 62-day time frame without triggering a rehearing to approve. Alternates, as we mentioned earlier, can help avoid this, but it needs to be made clear at the beginning of the proceedings whether the alternate is able to vote on the matter. And you cannot bring an alternate in late in the process to change the board's ruling. For matters of original jurisdiction, such as a review of a special use permit, if a motion fails, no action is taken. It is not a default denial. The members should continue discussing the application, its potential impacts, and consider possible conditions or alterations to the application that might lead to a majority action on the motion. If conditions are attached with approval, make sure they are enforceable by the zoning enforcement officer. Okay, so rehearing. The ZBA can at any time vote to reconsider a previously decided matter, even in the absence of new facts or circumstances. If there are significant changes in circumstances, it is considered a new application. Same hearing notice requirements apply as with the original hearing. The board must re-notice. It cannot rehear any case that has already been reheard, and you can only rehear once. To rehear a case that was previously decided, a member must motion to rehear the matter, and the motion must pass by unanimous vote of all present. After the matter is reheard, in order to change the original decision, a unanimous vote of all present is required. No new decision of the board may be made if the board finds that it would prejudice the rights of any persons who acted in good faith reliance on the original decision. Some courts hold the ZBA cannot rehear when there is pending litigation or where the court has already spoken. Now I'm going to turn it back over to Chris to wrap up with decisions and findings.
Thank you, Lindsay. So, as Lindsay said, wrapping up with decisions, findings, and filings, decisions must be made within 62 days after the close of the public hearing, and we don't usually have time at this point to make this plug, but 62 days is a magic number in New York State because there's 62 cities, 62 counties, including the 5 in New York City, and 62 days within which time a decision must be made after the close of the public hearing. For usually it's 62 days from the time the complete application that the planning board, let's say, or the ZBA in its original jurisdiction has to after the complete 62 days after the complete application is received. So the neg deck for seeker or a draft, the acceptance of a draft environmental impact statement, but yes, draft environmental impact statement, and the full application is received. It's within 62 days after that time that a public hearing must be held. But for ZBAs, it's within a reasonable time. That's what the statute reads. So within but it's the same for after the close of the public hearing. It's within 62 days the board must make a decision. So your minutes should contain a record of each vote. So who voted how, and the decisions should also include the language of the motion with any conditions that were attached to it. And this is really important because your motion and conditions, your motion should explain why there should be a basic explanation of how the tests or either the use variance, if that's what it was, or the area variance, how it related to the 4 or 5, as the case may be, factors in the test. So your decision should include the balancing test. All those factors in the balancing test should be addressed in your decision, along with any conditions. And this is very important for enforcement of those conditions when relief is granted by the Zoning Board of Appeals. And the motion, this is also very important, the minutes are important as a record of the activities of the Zoning Board of Appeals and your decisions. When you go back, if there are interpretations, appeals for interpretations on similar applications, then you would go back, future boards will go back into your minutes and your decision documents to find out what the rationale was of your decision. So these documents have a degree of historic value to them, and those decisions, and sometimes boards consider their decisions to be the minutes themselves. The minutes are the decision documents. Sometimes there's a separate decision document that's written, that's filed in the building file, and sometimes with the municipal clerk, with the application file. And other times it's a letter. It's the decision itself is the letter to the applicant. But that should be clear what the decision document is. And then that and findings, usually findings are written, formal findings are written to further justify and explain and support the decision and its rationale in a more expanded form with the four-part test for use variances and 5-part test for area variances. Findings are an analysis applying the law to facts, leading to conclusions, really supporting and justifying that decision, describing why the appeal was denied or approved. And sometimes an approval, a granting of certainly a use variance, but also certain area variances, the approval of area variances and use variances can be controversial, not just the denial to the applicant, but the approval to a potential third party who might challenge the decision. The having findings, especially if they're really carefully written and really based on the tests, the area and use variance tests, and they explain in detail why the decisions were made, they will really support you if your decisions are challenged. And very importantly, they also support why certain conditions were imposed. Findings are often drafted after the decision has been made, possibly in preparation. If the board is bracing itself to be challenged, they might draft with their attorney the findings and then approve them. So findings, if you have them on more controversial applications, will really support your decisions. And finally, and I should add here that the findings, they're findings worksheets that are attached to your handouts, which were emailed to you in PDF. At the end of the slideshow, there are sample findings forms for both use variances and area variances. And filing is really important. This is one of the reasons you should define what your decision document is. Everybody should be clear on what the decision document is, because when it's filed, when it's approved, when it's placed in under the clerk's control, and I had a question about this recently, if you don't necessarily file in the clerk's office, but the official place of filing the decisions, it might be the planning or building office, decisions should be filed within 5 days of the decision, and that starts a 30-day period in which somebody withstanding, either the aggrieved applicant who was denied or somebody else who stands to be harmed by the decision, can file an Article 78 challenging that decision in state Supreme Court. And if it's longer, that just extends the time, and that's really important. You don't want to file a decision hastily just to get it in within 5 business days. If you know you're going to be challenged, or if there's a good chance you're going to be challenged, a really complete decision document with findings will provide you, will really support those decisions. So that concludes the course. So as we said earlier, certificates will be emailed in the next week. So don't get worried if you don't have it by the time you wake up tomorrow. It'll be a few days. We have a lot of people on. This is close to our webinar record, and I think we have some time to highlight some of the many questions that came into Paula. She was typing away madly. Every time I looked back at the question and answer, I had to scroll down more because there were so many. Nearly 100, it looks like. It looks like it was in the 80s. I won't be the answerer of questions on the next one I'm presenting, so I won't be able to challenge myself to type as quickly as Paula has. So Paula, do you want to come on and highlight any of the questions that you were asked, and we can all discuss them?
I've mostly been just kind of hitting on trying to hit through the questions that they've been coming in like a lot quickly. I feel like I've been all over the place. Let's see, now it's all the thank yous, which we appreciate, and thank you for your service to our board or to your municipalities. Do you want to give some examples of conflicts of interest?
Okay, very simply, and I'll move to this slide because this is what you really have to know. If we don't answer your question, then call us or send us an email, and don't forget to check for our publications. Conflicts of interest, very simply, and because I'm not a lawyer, and sometimes this conversation can be very long, talking about conflicts of interest. A conflict of interest exists when a local official, in our examples here, because we're talking to local officials, stands to gain or lose financially by a decision that's made in that person's official capacity. So that is a true conflict of interest. If there is money at stake that could influence a decision, that is a conflict of interest. And if there's some kind of casual association with an applicant, for example, by a member of a planning board or a zoning board of appeals, if you just happen to know each other, that person voting is not necessarily a conflict of interest. If it's somebody, if it's your best friend, if it's your neighbor, if it's somebody you're related to, then there's more likely a chance that there could be a conflict of interest, and you as a local official should recuse yourself from voting in that case. Or if there's an appearance of impropriety, there might not be an actual conflict, but if it doesn't look good, then, and you're able to, you have a quorum, then recuse yourself from that decision. But the easy way to think about conflicts of interest is when there is money at stake to be made or lost, and your decision-making ability in your official capacity influences that, and it could influence your decision.
Yeah.
You want to add anything?
I think a common one that we get a lot is, you know, sometimes we're asked a lot about like board members sitting on the board, especially if you're looking for people who have maybe like, you know, an attorney or an architect or something. When you have an architect, that might be great. It might allow you to have, you know, better considerations in terms of your conditions of, you know, applications before the board. But if they also are a person who's doing a lot of business in town, another one is like a realtor. Mm-hmm. You know, if they work for everybody in town and they keep coming before the board, it becomes more difficult because there's usually conflicts of interest. So that's where you want to make sure that you have, you know, a lot of alternates available. But yeah, mostly the conflicts is really, it's mostly financial that we're worried about here. Another question came in, a simple breakdown of the difference between an area and a use variance. And I was like typing, I was like, well, area variances are dimensional, so, you know, setbacks, height restrictions. Use variances is really, again, tied to the uses that are allowed by your zoning. So, you know, if you allow convenience stores in your community, but we're talking about an application in a residential area, and, you know, commercial stores aren't allowed in that, they would have to have a use variance. So I think that answers that one.
Yes, good example, Paula. And I'll just add this. Sometimes I think to do it when talking about dimensional relief. Density relief. We talk about the three components of zoning: use, dimensional requirements, and density. And density, and there are variances for both use and dimensional, but what about density? It's one or the other. And in the course that we have that Monica authored, area variances, a deeper dive, there's a really good explanation of when a density variance seeking of relief from the density requirements of the zoning is a use variance, and then sometimes it's an area variance. And it is and I'll try to remember the really good example in that course, and that is if you have a single-family residential neighborhood or a two-family residential neighborhood, for example, and somebody wants to build a multi-unit building in that neighborhood, it is, or even turn a garage into another unit, let's say, add a unit. It's a use variance, but it's an area variance if it's a multi-unit neighborhood and if the zoning is multi-unit residential, let's say, and maybe there is a minimum square footage or minimum lot size and the owner might be able to add another unit but is just under the required dimensional requirement for that additional unit. Adding that unit in that instance would be an area variance. So I hope everybody followed me there, and that's a fairly common question that boards are faced with in that regard. I hear that you're still typing, Paula, and
oh yeah, no, there's like a ton still coming in.
There was another one.
Can you talk about why special use permits can be temporary? I think it's a reminder that they can be, you know, permanent,
yes,
temporary, or seasonal. Can you give some examples on that?
And even the variances can even be temporary if the request is temporary in nature. So if it's for, let's say, some kind of construction is going on and something's going to be changed temporarily for a period of time of construction, or the special use permit is temporary in nature, or it's not something that's permanent. It might be it might be a special use permit for some kind of event or for short-term rentals, which are don't really require any permanent building necessarily, but short-term rentals are kind of an event. And your law should, if it's a special use permit, if it's a special use permit that's being sought and the board wants to grant it as a temporary special use permit, or some kind of renewable special use permit, the board must be authorized to do that, it must be authorized by the local governing board to grant the special use permit on a temporary basis. So it might be for an accessory dwelling unit on a temporary basis. When they first started becoming popular, that was something that was entertained by manufacturers of accessory dwelling units, but a lot of the time the investment is so great, people don't necessarily consider them temporary. But that is the application there. And if you still have questions, there are a lot of people still on. If we're not answering your questions,
yeah, just
that email address and phone number on the screen, use them. So let's talk about let's do a couple more. We have about
this one's kind of weird. If there are separate guidelines for home occupations like hairdresser, car detailing, would that be a use variance even though there are provisions addressing home occupations, like you can't use more than 25% of the dwelling? Does this make sense?
There are provisions in the building code for where there's a cap. It's in the residential code, I believe, and there's a cap on how much of the residence you can use as a home-based business before another code is triggered. So it's not an absolute max for a home-based business under the code, because the code is not concerned about use, but it's concerned about safety. So if you're using more of your residence than the cap in the code, then higher code. Maybe the regular building code, not the residential code, has to be followed. So that's a good cap to observe for that reason. But home-based businesses, how much and to what extent they're permitted is up to the local governing board. And of course, the members of the Planning Board and the Zoning Board of Appeals should be involved with those decisions in their recommendations. There might be problems with home-based businesses that the local governing board wouldn't necessarily be aware of without the input of members of the ZBA. Does that answer that question, Paula, do you think?
I think so. This is a good one. Can you elaborate on the slide that states a motion or resolution only passes with a majority of its entire board?
I can take that one if you want.
Go ahead, Lindsay. Give
And
it a
you can
shot.
add to it if I miss something.
Sounds like a plan.
Okay. So in that slide, I did just give an example, and I'm going to use it again because I think it helps to visualize it a little bit better. So if you have a 5-member board and only 3 board members show up, so you have that quorum, and you have the majority of the board, but you only have 1 yes vote and you get 2 no votes, if that's for an appeal, a variance, or an interpretation, that would be a default denial. Because there's not a majority voting yes. So you'd need all 3 of those members to say yes to that action if it was an appeal, variance, or an interpretation. If it was a matter of original jurisdiction, such as a special use permit, and the same vote were to occur, that would be a no action. Did I say the right thing? I'm sorry, I lose my train of thought.
Yeah, it would be a no action.
If it's original jurisdiction, it's no action. If the board can't agree.
Yes, and so in that case, we encourage the board to continue discussing the application and try to come to an agreement with the applicant. So either provide more conditions in order to reach an agreement, or you're gonna, or try to work towards working together to deny it. I mean, it really is depending on what the situation is.
Yeah. And I think it's good to kind of swing back to quorum on this one. If somebody recuses themselves, that means that you might lose your quorum. So it's important to have alternates, if you do have alternates in your community. Kind of have somewhat of an idea of where it's going to go. If it's really tight and somebody's going to recuse themselves because they have a conflict of interest, you want to make sure on a board of 5 that you're going to have 3 other people to do the work. So you really need 4 people to show up that night. Because there were some questions that also came in on that one. So it's good
Very
to
good
kind
point,
of
Paula.
put those together. Also, just a reminder, like, you know, when there was a couple of weird questions that came in that was like, you know, should the attendee or should the applicant be at the meeting? I mean, there's nothing that forces you to have them be at the meeting, but the whole point of the variance request is you're supposed to kind of go back and forth with the, you know, with the applicant. You know, you're allowed to ask questions, you're allowed to put your thinking caps on. And if they're not there to answer those questions, it makes it that much more difficult to approve their variance request, because you can't really go back and forth about, well, why do you have it on the side of the property? Would it make sense if you put it, you know, in the back of the building instead of the side? So I think, you know, again, you can't force people to show up to your open meetings, but your applicants, if they want their variance request, they should definitely show up. Or, you know, in other communities, they might, you know, they might send, you know, they might send a representative for them. So an attorney, they might come with an attorney. That's fine. But, you know, they should probably, you know, show up if they want their variance.
And the board might not make a decision if they have questions. It's probably more efficient for the applicant to just come to the meeting, because it could drag on with the board not really having all the information they need to make a decision. And I should add here because I did the slide about decisions within 62 days.
Yeah, we're getting questions about that too.
Yeah, of course. Subdivision is the only review that for which there is an automatic consequence to missing the 62-day deadline, either one of them for that matter, the hearing or the decision. It's a default approval for subdivision. But for the other reviews where we have the 62-day deadline to make a decision after the close of the public hearing, there's no automatic consequence. It's there so that the board doesn't drag it out 6 months or 2 years. But if the board needs a little more time, there's not, an axe isn't going to come down on them on day 63. But I also want to add to Lindsay's explanation of the decision, of the taking action slide and the default denial, because it can be a little misleading. And I misunderstood this, and I know Lindsay said it, but I'm just going to say it again. The term default denial is misleading because it's only a denial if the board can't get a majority, if there's not a vote of the fully constituted board, a majority of the fully constituted board before 62 days is up. So if at the initial meeting there are 3 people, it's a 5-member board and 3 are present, 2 vote for the area variance and 1 votes against it, even though it's a majority of those present, it's not a majority. 2 isn't a majority of the fully constituted board. Well, so it's denied, and if they never vote on it again for 62 days, it's denied. But if at the next meeting there's a full board there and somebody brings it up and says, let's vote again, and the same 2 vote for it, the same 1 votes against it, but the other 2 vote for it, that's 4-1, the default denial is overturned and it's granted. That's as long as it's within 62 days. So there is that significance of the great significance of the 62-day deadline when the Zoning Board of Appeals is acting in its appellate jurisdiction and can't get that full vote. So I hope everybody follows that. And if you don't, call us or send us an email. Any others, Paula, as we get close to 8?
If the owner of an owner-occupied house wants a use variance to add a business in the house, what is the reasonable rate of return? Is it the rental value of the house? Not sure.
Oh, that would be, that's an interesting question, but it's really hard to say because that would be to turn a single-family residence into a business is that's a tall order, and so I think the rate of return is what you could get on renting the house. Consider your other options: renting the house to somebody or selling the house. And right now, housing is in great demand. So when I first started this job, it was the other way around. Businesses were more lucrative. Now it's like housing is more lucrative. People are converting storefronts to residences because rentals for housing is more lucrative in many places than rentals for businesses. So I think it would be a tall order, and the reasonable rate of return would be on what the house would sell for or what it would rent for.
Let's see. I think we've kind of covered most of it. There are some that came in just as you guys were kind of finishing up that. I tried to hit all of them. If I haven't, like I said, send us an email. There was one about, can a member be out of town and still vote? That's the open meetings law. I told them specifically to send us an email. We can talk about it because in planning board we talk about it, but we don't talk about it in this one. So So send us an email if you have questions about open meetings law.
And I'll just say this, the vote, the extraordinary circumstances vote in which a member in an undisclosed location, not a public location, can participate, you still need a quorum of the board in the public location. So it's not it's not something that a lot of boards are doing.
Yeah, yeah. But you can participate if you're from another state. If you are online, it's noticed as an open public meeting, and the public is allowed to attend. Let's see. I think we've kind of hit on everything. Like I said, if we haven't gotten to everything, I know people are asking for the questions. And WebEx has been kind of wonky here this evening. We are recording this. All this discussion at the end will be included in the recording. So feel free to do that. To go back to that, it'll be on our online schedule sometime soon. Otherwise, do you guys want to wrap up and say goodnight?
Well, before I do, I'll just remind everybody once again, we have a huge audience tonight, and I think some of that can be attributed to the extra outreach that we did using the agency's communications office. And those people who haven't taken our training before, either online or in person, I encourage them to go to our website. The link is on the screen. The training section of the DOS's website, local government training, or just do a search on local government training program. And take a look at our schedule and make sure you connect with your county or regional planners and be on their mailing lists because they are a critical component in our outreach. So, and if you don't know who your county or regional planner is, let us know and we'll figure it out with you. So I'll leave it there. Thank you again, everybody, for participating and for logging on tonight. And remember our During the Day webinar on Thursday, January 22nd at 2. Check our website if you didn't know about it for the registration information, and encourage your municipal staff to take that course, and other board members too. It's appropriate for all.
Absolutely. And thank you again for your service to your communities and for getting training tonight. We appreciate your time. And with that, I think we can close it out. And we keep getting a lot of Go Bills, so we'll say Go Bills.
Thank you, everybody. Good night.